Hello, and thank you for joining us. This is No Soundbites Allowed, and I am your host, Michael Voss, Dragon of the Southern Tier. I'm happy to be here with you today. We're going to be talking about something that just broke in the news last night. You may have heard about it, where the Ninth Circuit Court has just ruled that open carry, concealed carry are not allowed by the Constitution, that the Second Amendment does not apply, that states have power over the citizens when it comes to self-defense. Obviously, this is a big deal. And this is something that's very important. We want to talk about this to let you know not only what was actually said, but also how is this going to affect you. Now, if this is the first time that you've been with us on this channel, we thank you for joining us, and we do long-form political commentary. Also, every Sunday at 2:30 p.m. Eastern Standard Time, we do a live stream with you, talking to you on Facebook, on Twitter, on YouTube, all social media, DLive, talking with you and taking your text, your chat, your calls to speak about the issues of the day and to allow you to express your First Amendment right, your freedom of speech, because we believe in our freedoms on this channel. And we look forward to seeing you from anywhere in the world every Sunday at 2:30 p.m. Eastern Standard Time. Now to the issue of the day and the news that's going to be spoken about a lot. I mean, there's been a lot going on with gun control over the last couple of weeks. Because of the shootings in Atlanta and because of the shooting in Boulder, Colorado, it's been a troubling time for many Americans. And let us start off with, we give our condolences to anyone who has lost their life to any form of violence, especially gun violence. But is the answer de-arming the American citizens? Is the answer to try and remove the 393 million firearms in the United States, to leave the 165 million estimated U.S. citizens, to take away their ability to defend themselves? It's a troubling question. It's a difficult question. But let's understand this. Now, on this channel, as you may be aware, we have been talking about gun control and the Second Amendment, amongst other things, for many years. In fact, this is an article talking about mass shootings and gun control and the effectiveness of gun control on mass shootings. This article is from October of 2017. You may have seen more recently us speaking about this back on March 22nd, just 3 days ago. But what happened most recently and last night, as reported by CNN, the Federal Appeals Court says that states can restrict open carry of firearms. That's not exactly correct. And this news came out at 8 o'clock at night. And a lot of people may have seen this story, but not understood. Even though the Ninth U.S. Circuit Court of Appeals ruled in a 7-4 ruling to uphold the state of Hawaii, which denied openly carrying a firearm in public to its citizens, and in particular George Young in this case. They stated, and as quoted by CNN, there is no right to carry arms openly in public, nor is any such right within the scope of the Second Amendment. That is a powerful statement by a U.S. court. It effectively nullifies the Second Amendment for anyone outside of their home, and it makes people defenseless. This is a big deal. It affects every state in the United States, and of course, this is expected to be going to the Supreme Court for a clear definition, because it violates on its face the decision of D.C. versus Heller, where it was decided that yes, you can defend yourself with a firearm, and yes, you do have the ability to carry a firearm. Now, this is something that is very controversial, and we're going to get into this in just a moment to give you the details. But I want you to understand something. This isn't new. This is something that has been going on now for a long time. And we've been told for quite some time by many elected officials that they are looking to remove the Second Amendment, that they are, in fact, going to take your firearms. Many people I've spoken to in the Second Amendment arena, those who are in favor of it and those who are not, have constantly made the claim that no one is coming for your firearms. No one is trying to take your property. They don't want to leave you defenseless. That's not entirely true. And we want to be very clear about this. And we're going to go back to September of 2019, where we had said at the time, but the argument always tends to start with the same kind of place. They always start with the same kind of statement. Have you ever noticed that? They start off with, no, we don't want to take your guns. We don't want to take any of your guns. That's kind of like in 2018, February of 2018, as reported by Real Clear Politics, Representative Himes says that nobody wants to take away your guns. We just want to be like Australia, Canada, and Great Britain. Now, let's think about that for a second. We want to be like Great Britain. Great Britain has gone over 300 years without a firearm. They're illegal there. You can't have a firearm there. Australia had a big ban recently, and so the public can't get a firearm. Canada, these are places where you can't, as a regular citizen, defend yourself from the government. These are places where the culture has always been that, or at least very recently in the case of Australia, there shouldn't be firearms in anyone's hands except the government. So when you hear progressives and Democrats like Jim Hines, Representative Jim Hines, when they say, no, it's silly, it's meaningless. No, we shouldn't take away anyone's guns, except we want to be like the places that don't have firearms, that people are not allowed to defend themselves. Now that is talking about gun. So we made it very clear at that time when we were talking about this, and this was right after the Parkland shooting in Florida, and Congress was again looking at how they could restrict the ability of American citizens to own firearms and how to protect ourselves, our schools, to be able to just have the Second Amendment. This was a very troubling time, and there were a lot of troubling statements that were being made at that time. And one of the things that was being said very clearly and very directly to American people, unlike Representative Himes at the time, we also heard very clearly this statement. We wouldn't dare take your firearms. And then we heard the honest truth finally show up. When we heard Beto O'Rourke, when he was on the stage in September, along with the other 2020 Democrats who are all looking to get elected as president, and his answer was, hell yes, we're going to take your AR-15, your AK-47. They promised that they're going to take it away. It was very direct. I mean, you can't get more than direct than Beto O'Rourke saying, no, we are going to take it. You can't get more direct than that. We were told by 20 Democrats on a stage, we're going to take your AK-47, we're going to take your AR-15, we are going to take away your ability to defend yourself in public and at your home. Because you don't deserve that right, according to some Democrats. And on that stage happened to be Joe Biden as well. And Joe Biden, as vice president under President Obama, was a very strong advocate against the Second Amendment and to deny people's rights. And this seems to have transferred itself to the Ninth Circuit Court, where we have seen courts become more and more like judicial advocates, activists, going out to change laws or change the interpretation of laws to gain a political advantage for whichever side they may be on, and to take a position that leaves the American citizen with less rights and less freedom and less safety as a consequence. Now, this is an important idea, and this is very important. I want to go into what was actually said. Because if you look at what CNN had said, again, their quote, "There is no right to carry arms openly in the public, nor is any such right within the scope of the Second Amendment." That's not exactly what they said. If you go to the actual decision, which we are showing you right now on screen, and the links for everything we are discussing will be in the description at the end of the video. What we're seeing right now is their actual decision. How did they come to this point? And one of the things that we think is very important, and this is found on page 34 of the entire decision, is this section here, where they state, Parler, which is the case decided by the Supreme Court on Second Amendment. Parler held that an outright ban of firearms in the home violates the Second Amendment. The handgun ban amounts to a prohibition of an entire class of arms that is overwhelmingly chosen by American society for that lawful purpose. Under any of the standards of scrutiny that we have applied to enumerated constitutional rights, banning from the home the most preferred firearm in the nation will keep and use for protection of one's home and family would fail constitutional muster. The extent to which the Second Amendment protects the right to keep and bear arms outside the home is less clear. To that issue, Parler posed more questions than it answered. By tying the Second Amendment to the need to defend oneself, Parler implied that some right to bear arms may exist outside of the home. That's a very important statement. And that's not being conveyed by CNN. It's not being conveyed to the American people that this is important to understand. It is clear from the Supreme Court of the United States that there is a right to carry a firearm. There is a right to have a concealed or open carry of a firearm, which many states allow. An essential part of this argument and this discussion that is not being conveyed by CNN, that is not being conveyed by the major news media, and is being denied to the American people. And I think that's essential to understand, because even the court understood that this is a question we have to address. That there is a right, but how far does that right go? Now, we're going to move on a little bit because we're going into the dissent. One of the four judges that disagreed. And on page 128 of the decision, it was O'Scanlan, the circuit judge, who dissented, along with Callahan, Ikuta, and R. Nelson, circuit judges. And in that decision, O'Scanlan, I know I got his name wrong, I apologize. He says, the Second Amendment to the United States Constitution guarantees the right of the people to keep and bear arms. Today, a majority of our court has decided that the Second Amendment does not mean what it says. Instead, the majority holds that while Second Amendment may guarantee the right to keep a firearm for self-defense within one's home, it provides no right whatsoever to bear, in other words, carry that same firearm for self-defense in any other place. This holding is as unprecedented as it is extreme. While our sister circuits have grappled with and disagreed over the question of whether public firearms carry falls within the, quote, inner core, end quote, of the Second Amendment, we now become the first and only court of appeals to hold that public carry falls entirely outside the scope of the amendment's protections. In so holding, the majority reduces the right to, quote, bear arms, end quote, to a mere ink blot. The majority's decision undermines not only the Constitution's text, but also a half a millennium, 500 years of Anglo-American legal history the Supreme Court's decision in District of Columbia versus Heller, and McDonald versus City of Chicago, and the foundational principles of American popular sovereignty itself. I respectfully dissent. That's a very powerful statement being made by the judge, and he is looking at the implications of what has been said by the Ninth Circuit Court majority, that the American people do not have a right to defend themselves, that you are helpless in the face of this kind of, in the face of any kind of violence being brought against you, whether that would be a mass shooting, whether that's a school shooting, whether that's an attempted robbery, whether it's any form of violence, gang violence, anything. And this is very upsetting. He goes on to say several things, and we want to look at maybe one or two of them here. And I believe, here we go, in page 133, it is Hornbook constitutional law that to bear arms implies something more than mere keeping, as cited by Thomas Cooley in the General Principles of Constitutional Law in the United States, 1880. Indeed, the Supreme Court in Heller was clear about what it means to, quote, bear arms, end quote. At the time of the founding, as now, to bear meant to carry. That the Constitution delineates a specific right to carry a firearm as distinguished from the right simply to keep a firearm strongly implies the right to take one's firearm outside the home in which it is kept. It is clear, foundationally and essentially, explicitly, that your rights don't end at your doorstep. And if we are to understand that our rights end at our doorstep, that's troubling for all of our rights, like your right to privacy, your right to free speech, your right to, well, live life, pursuit of happiness, everything. It changes everything. I want to also go on, and there's a couple of different sections here that I want to get to, but I want you to understand what is being said by judges about this case, about what is being explicitly stated here that is not being conveyed by the major media, because the major media wants you to be afraid. They are pushing a message of fear at this time because there is an outcome, there is a goal that they want to have. And it's terrifying. On page 182, it says, part of the statement is, under our court's framework, if Hawaii's law amounts to a destruction of the core right, meaning the Second Amendment, it must be held unconstitutional under any level of scrutiny, as decided by Sylvester versus Harris, which was judged by the Ninth Circuit Court in 2016. And if it severely burdens but does not destroy the core right, it still warrants strict scrutiny. Though it is doubtful whether Hawaii could prevail under either standard, the unavoidable reality is that Hawaii's severe deprivation of the core right to carry a firearm in public can only be understood as amounting to a total destruction of such right. It is thus necessarily unconstitutional. It is, by its definition and by its existence, unconstitutional. It's a very clear and very strong statement that is being made here. And it has implications that are wide reaching. Now, this was also being stated by one of the other judges in this case. And I'm going to be going to page 194. But one of the other judges mentions very clearly, because they're understanding what's going on here. And one of the other dissenting judges mentions, to be sure, I do not reach this conclusion without appreciation for the real and serious problem of gun violence, a problem which I do not take lightly and which the state of Hawaii quote, has understandably sought to fight with every legal tool at its disposal, end quote. And nothing in my analysis would prevent the state from regulating the right to bear arms, for the Second Amendment leaves the state with a variety of tools for combating the problem of gun violence, including some measures regulating handguns, again citing Heller. Yet for better or worse, the Second Amendment does protect the right to carry a firearm openly for self-defense in public, and Hawaii's near complete ban of the open carry of handguns cannot stand. I know most people aren't going to read the Ninth Circuit Court's decision. Most people aren't going to read, nor are they going to be told what the dissent had to say and how strongly they had to speak about this. You deserve to know the full story, because the media is talking about only one thing, and they're being very clear about it. Again, I refer back to the CNN report, which we have seen duplicated through most of the major media. There is no right to carry arms openly in public, nor is any such right within the scope of the Second Amendment. That's the message they want you to hear. They want you to hear the same message that was coming from Beto O'Rourke, that was coming from the Democratic candidates on the stage in 2019. They want you to hear the same message they've been telling you for the last 30, 40 years. You don't get to have a firearm because they don't want you to have one. Even though they are the very people saying this. Joe Biden, Kamala Harris, Speaker Nancy Pelosi, Chuck Schumer, Representative Himes. So many of these individuals, they are protected by bodyguards who are armed. They are protected by Secret Service agents who are armed. They have isolated Washington, D.C. at a cost of over $150 million to date and increasing per day with our National Guard, who are armed against the American public. They want firearms for them, but not for you. And this is a terrifying thought. And we see this happening even as more and more progressives are asking the Biden administration to go out there and to make this happen against the will of the people, to do this without Congress. In fact, they're being asked, Jen Psaki is being asked by the White House where it stands on the executive action by using an executive order to circumvent Congress and therefore the American people. And her answer is, quote, I don't have anything to predict on whether there'd be something independent. I think we're looking at what a number of passionate gun safety advocates on the Hill have already introduced to see where we can help push the boulder on that. Well, that's a very interesting statement and very interesting phrasing. Gun safety advocates. Because there's unsafe gun advocates in the world? Because someone is advocating unsafe use of firearms? Please name that person. Please name that organization. Because as far as I am aware in the United States, that doesn't exist. There is no such advocate. There are no such people. But they're trying to phrase it that way. They want you to think that if you aren't with Joe Biden and with the anti-Second Amendment advocates like Sheila Jackson Lee, well, then you're just unsafe. You want people to be endangered. That's not what we're talking about. That's not what is on the table. That is not what was just decided by the Ninth Circuit Court. And to do this by an executive order is circumventing the American public. That defeats the reason why we have a Congress, why this discussion needs to be held, and why members of Congress are obligated to vote as their constituents decide. This is a very important thing. You know, one of the reasons why we're told by gun safety advocates that we need to be protected is because of assault weapons. something that is ill-defined and incorrectly defined on a regular basis. We are told often that these are weapons of war, they're weapons of mass destruction, that they are an assault weapon, which would mean and is defined as a machine gun, which they are not. They are conflating what is in a movie and what is in reality, because that's the only explanation. As we see when we talk about things like, and as we have covered here, back in July of 2018, when Frank Johnson, a licensed New York firearms instructor, was speaking to the public, talking about the Ruger Mini 14, a firearm that is at the same time both considered unconstitutional, illegal, and legal. The only difference being the cosmetics of that firearm. And in fact, Frank says,
the second picture, while functionally no different from the first, would be considered an assault rifle merely because of the cosmetic changes. Each rifle fires the very same bullet at the very same velocity, at the very same rate of fire, which is determined by the shooter, not the gun. And they have the very same level of accuracy and lethality.
So I want you to understand, even gun instructors, everyone who has actually used a firearm and not looked at a movie has a very clear understanding. Firearms are not movies. And these lawmakers like Beto O'Rourke, like Joe Biden, Kamala Harris, Representative Sheila Jackson Lee, and many others, they misunderstand. They seem to think that a cosmetic difference in the way a gun looks somehow has some impact on the way it functions. And they want to ban these firearms based on their looks because it's scary looking. Not because you're going to be any safer, but because they want you to not have a scary firearm. And what falls under that definition of scary firearms? Anything that would fit the scary term assault weapon, assault rifle. That's just ridiculous. In fact, since 1934, under the National Firearms Act, we are already banned in the United States the ability for the average citizen to own a machine gun, a flamethrower, a rocket launcher. That's already been covered. And by the way, it is legal for an American citizen to own any of those items, as long as they have a license, a special license, just for that. And over 5,000 people in America do own that license. And that's why we don't see gangsters, criminals running around our streets, drug users and drug lords. They're not carrying machine guns. In fact, they're not even carrying assault rifles or rifles. No, what they carry almost always is a handgun. But that just means that, according to Joe Biden, according to Representative Sheila Jackson Lee, what we need to do is just ban all guns. That's the answer. You don't have a right to this, which is what the Ninth Circuit Court has now decided. You don't have the right to protect yourself. That's a terrifying thought. And they're saying this because they want you to be afraid. I'll give you an example of what I mean here. When I say they want you to be afraid, this is CNN. And I'm not just picking on CNN, but I'm trying to make sure I'm giving you a clear understanding of what the major media is doing to support Joe Biden and the other members of Congress who are trying to force this on you, to deny you your rights and your freedoms to protect yourself, your family, and others. In Atlanta, last night, Wednesday, the 24th, it was reported at 10 p.m. that the Atlanta police detained a man with 5 guns, body armor in a grocery store. Now, when you read the story, we don't know why that man had that firearm. We don't know why he had the body armor. There is no indication that he committed a crime. There is no indication that he was intending to commit a crime. If you read through the article, they don't know why. The man entered a Atlanta Publix supermarket. He was seen openly carrying a rifle, and he entered the bathroom. By the time he came out of the bathroom, he was immediately detained by police forces. The man, by the way, and possibly why you haven't heard about this story, is he was 22, and his name is Rico Marley. Now, as we have often seen in many of these stories, when the story doesn't target a white male, we don't hear the names of these individuals very quickly. We don't hear what kind of firearms they were carrying with them. We don't hear the message because it doesn't fit a theme. This is why this isn't national news, why it isn't being covered by all of the news media and blasted in every single news channel 24/7, because it doesn't make you afraid, per se, or it doesn't make you afraid of the people they want you to be afraid of. And that's an important distinction. And by the way, when I say Rico didn't break any law, this is the Georgia gun control laws. And in there it isn't an illegal firearm because it's not a sawed-off shotgun or a sawed-down modified rifle. It's not a machine gun. It's not a dangerous weapon. It doesn't have to worry about the waiting period to be able to have that. He's not a convicted felon, as far as the news has reported to this date. He didn't break the law. Going further, if he has a license, which was not addressed in the CNN news article, whether he did or did not, police have not reported that yet. But if he has a license to have a firearm in Georgia, then that such license or renewal license shall authorize that person to carry any weapon in any county of this state, notwithstanding any change in that person's county of residence or state of domicile. In essence, and directly for the state of Georgia, if he has a license to carry that firearm, he can openly carry that rifle. That is his right. He can wear body armor. That is his right. There is nothing wrong with that. And that doesn't mean that he's guilty because you saw a scary weapon. You saw him with a scary rifle. Does that mean he is guilty of a crime? No. Does that mean you should take precautions? Maybe. But we have to understand people have rights. And it's not the first time that we've seen an individual go into a store just to make the point that they are openly carrying, not to cause harm, but because it's their right. And rampant fear doesn't make people safer. The gun laws, and this is gun laws in Georgia, are very clear that and this is something that's opposed by the Ninth Circuit Court at this time. Is a permit required for open carry? Of a handgun, yes. Of a rifle, no. Can you have a concealed carried weapon? For rifles, yes. For handguns, yes. You have that right in the state of Georgia. But according to the Ninth Circuit Court, you no longer have that right, which means that the Ninth Circuit Court has violated the 10th Amendment in their statement, because a state has provided the people that right. It recognizes that according to the Second Amendment, you have that right to have a firearm openly carried, and in some cases, concealed. But that's not what the Ninth Circuit Court has just decided. They have violated the state's rights, the individual's rights, by saying that right doesn't exist, even though they cite Heller, which points out there is that right, even though, as we see from the dissenting judges, that right is recognized both by definition and by history and by fact. And this is also true, if you're wondering, in Colorado, because Colorado also has laws that Colorado allows a person to carry a firearm in a vehicle. But according to what we're hearing from Ninth Circuit Court, you would no longer be able to have that right. Because if you cannot openly carry, if you cannot conceal carry, how can you carry that in a vehicle? It's a very troubling thought. And we need to understand these laws as they exist so that we can better protect ourselves. Because if we cannot protect ourselves, then what does it matter? You know, and I want you to be very clear, because if you look at the gun laws in Colorado, again, are there laws to reduce the size of a magazine as being proposed by Joe Biden and many of the Democrats who oppose the Second Amendment? Yes, they have restrictions on magazine capacity. Do they have red flag laws? Yes, they have red flag laws. Do they have background checks? Yes, they have background checks as a part of their law. Are items like machine guns restricted from the average American citizen? Yes, they are restricted. And do you have a right to conceal your firearm in your vehicle? Yes, you have that right. Do you have a right as a citizen to have a concealed carry in the state of Colorado? Yes, you have that right. And this would allow you to be able to protect yourself. So the very things that they're saying are going to protect you, that Joe Biden has said, well, we have to do this to protect you. We have to be able to have to not have concealed carry, that you have to ban certain firearms, which we already see states and the nation has already done, that we have to go and have background checks. They have that. It didn't stop anyone who had a criminal intent and had a mental derangement. That you have to have red flag laws. We had them in Colorado. It didn't stop anyone. The family didn't act. The law didn't work. Not because it was a bad law, but people with criminal intent, people who are mentally deranged, do not care about laws. But who are these laws going to impact? How are they going to affect people? Let's understand this clearly. Because if we are to go with Joe Biden, if we are to go with Representative Sheila Jackson Lee on this path, if we allow the Ninth Circuit Court to stand as it is and not allow American citizens to defend themselves outside of their homes, then as we saw in December of 2019, there was a gunman at the West Freeway Church of Christ in Texas. That gunman was stopped by another member of the church who had a firearm, saving many lives. Not the police, not the U.S. Armed Forces, a citizen who was armed outside of their home at a religious event, at a church, protected the people of that church because they were able to carry a firearm. And under the guidelines being suggested by Joe Biden, by Representative Sheila Jackson Lee, by those who oppose the Second Amendment, who claim to be gun safety advocates, these individuals would have allowed the death of more people. And by the way, the state of Texas is very clear about what they believe in, that you are able to carry a concealed firearm on a campus, that you are able to have open carry of firearms, that you can have a license to be able to carry a concealed firearm. You know, there's also the Gene Assam saved lives at the New Life Church because there was a shooting there in 2011 in Colorado Springs, Colorado, and she was able to save lives because she was armed. What about when we see people in their homes? How about on January 12th, we saw that Sarah McKinley was able to save her life and that of her child, a newborn baby that she had. And she was able to save her life and that baby's life because she was targeted by criminals specifically to cause violence and to steal her property because they were looking for drugs. And she was able to protect herself because she had a firearm in the home. Again, that scary firearm. that many of these advocates, like Representative Sheila Jackson Lee under H.R. 127, would have prevented. This is the gun safety advocates. This is what they are looking to do. Representative Sheila Jackson Lee would have stopped that woman. She would have stopped this woman, Sarah McKinley, from protecting her life and that of her newborn because of H.R. 127 that Joe Biden and the gun safety advocates want to impose against the American people. They want you to be less safe so that they can have more power. I'll give you another example of what we're talking about here. It was a man in Florida. He's 71 years old. This is in July of 2012, where he was able to protect individuals in an internet cafe as robbers who are armed with weapons came in demanding to everyone's money to rob them. And because he was 71 and he had a concealed carry weapon that the Ninth Circuit Court would not allow, he was able to protect that business and the individuals in that internet cafe. If it were up to the Ninth Circuit Court, he would not have that right. He would not have been able to defend himself outside of his home. And therefore, who knows how dangerous that incident may have become. How about we look at another case? And this one, again, is in the home, where, as reported by NBC News, these are left-leaning sources I'm using, a pregnant Florida woman used an AR-15. Yes, that AR-15 from the movies, apparently, the same one that Joe Biden is saying you cannot own, the very same one that Beto O'Rourke is saying he is going to take away from you, the very same one that we saw Representative Himes is saying you can't own because you can't have it in the United Kingdom, because you can't have it in Australia, because you can't have it in Canada, countries that will not allow you to defend yourself, that we shouldn't have it here either. Can you imagine that this woman, her husband, is being pistol whipped, her daughter is in danger? These individuals have a clear intent to harm this family in their home, and she is pregnant. And were it not for that AR-15, they may not have been alive. And because of Representative Sheila Jackson Lee, because of Representative, I want to be very clear here on who we're talking about, because of, Representative Himes, we know that they would have removed people's ability to take care of themselves. We've tried to give you a very clear answer. We've tried to give you a very clear answer that for many years, actually for the 15 years we've been covering the Second Amendment, we have seen the same answer coming from the right, the far left, that you must not be armed. You cannot have the right to defend yourself, that you are not safe, that the only answer is the government. And we have seen over and over in those same 15 years, case after case, where people are defending themselves, women are protecting their families because they were armed. We have seen that over and over again, people who have been able to open carry and conceal carry have saved lives countless times because the police can't be everywhere. The very same police that these very same individuals are saying we need to defund and there must be less of them. Think about it. You're being told on one hand, you don't need to defend yourself. The police will take care of it for you, except they can't be everywhere. And by the way, it is these same individuals who are saying, and we need less police so that you can be less protected. But you can't defend yourself. You can't own a firearm, even though it is explicitly stated and implied in the Second Amendment, even though law has been very clear about this right existing, at least to some extent. They're now trying to eliminate it. They're trying to live up to the idea as stated by Representative Himes, as stated by Beto O'Rourke, as stated by Joe Biden and many Democrats. We've tried to give you a very clear answer. We've given you a lot of sources, a lot of information. We've tried to do what the news media won't do, because it does take more than 30 seconds to explain this, to go over the details of your rights and what explicitly has been said and how this will directly affect you. By the Ninth Circuit Court doing what it has done, to say that you do not have a right to conceal carry or openly carry a firearm, that you cannot protect yourself, you do not have a right to protect yourself outside your home. This has enabled Joe Biden and encouraged him, as he is being encouraged by the far left, to try and use executive orders to do something that Congress has not and will not allow. Even as they are trying in Congress to ensure that you cannot possibly protect yourself. This is dangerous. We are in a realm of serious consequences. If you've been saying to yourself, as people have said to me many times over the years, this will never happen, it is happening. If you're one of those who have said, they'll never be able to pass this, they are passing this. It is getting through the courts. If you're saying that this can't affect my life, it is affecting your life. And criminals and the deranged are paying attention. They know that you are becoming less and less able to defend yourself and your family. You are being able to protect less and less. It's a troubling time. These are troubling issues. And we all need to be aware, and we all need to take action. If you disagree, if you think we've misunderstood, if we have not seen the information, if we have missed something in the reading and the information we've provided, we want to hear your answer. We want to hear the other side as well. We want you to engage in this expression of free speech. And we look forward to seeing your comments, as well as to hear from you every Sunday at 2:30 p.m. Eastern Standard Time. And we hope that if you have found this to be informative, interesting, to like it, to share it, and most of all, to subscribe, so that we can make sure more and more people are able to get full details and a full understanding of what is happening and how it affects your life. We hope to see you very soon, and we hope you will be well. Thank you.